Good morning, Ajo.
Good morning.
Yeah, good morning. It's still morning.
Yeah.
I think you can appreciate that this this morning has been very hectic, not for anything else, but about just setting up this.
Yeah, indeed, yeah.
We're supposed to be recording inside, but Jetco decided to go off. And the studio is not conducive with that type of power. So, but hey, we make with what we have. So, welcome to my podcast. I think this has taken a bit of time, right?
Yeah, it has.
Yeah.
I was almost asking, why am I not being called for the podcast?
We're saving you when we did all our reforms.
Yeah, no problem. Yeah.
Okay, good. So, just for the benefit of my audience, who probably some people who don't have any background about you, maybe you can just tell us your name and what you do.
Well, my name is Ajo Noel, or you can call me Ajo Onyohisa. I'm a lawyer by profession. I'm a lawyer by training. I practice law as an advocate. I also teach at the university, at the School of Law, and I head a department known as the Commercial or the Business Law Department at the School of Law, University of Juba. I'm also into farming, so I'm a farmer at the same time. A husband, a father, that's me.
Okay, that's quite a comprehensive profile. Just tell me a little bit about your background, like where did you grow up and study?
Yes, I was born in Juba in the 80s, and then 89, I think my mom, because my father was already was separated because of the conflict, the Liberation War. My mom did what she could from Juba here towards Yei to Kajukeji. At that time, late 80s, she was working with World Food Program. And so, and at the time, Kajukeji was under the liberated areas. 89, 90, we were there. So I started schooling really primary from Kajukeji. And then when we were kicked out by the Sudan Armed Forces, that was 94, we moved to the Ugandan border. From to other people moved to Bamure. We were pushed straight to Moyo district, and then there to Ekam across the river. I think that was in Ogujabe. Then from there we were moved to Kali. That is Palaronya refugee camp. Then from there again, of course, we crossed back to South Sudan to Bamure. So
where is Bamure?
Bamure is just the border between South Sudan and how do I say this? Yumbe district now or Moyo district in between there, but it's part of South Sudan, Kajukeji County. Yeah. So
that's where like you probably started most of your studies.
Yeah, that's how I started my my primary, and then when I finished primary 7 at the Kali Central Primary School, that is in Palaronya refugee camp. And then after that, I joined St. Augustine Seminary of the Catholic Diocese of Yei. I was in St. Augustine from senior 1 to senior 6. From senior 1 to senior 5, then I was suspended for a year. Apparently, I was a ringleader who organized a strike in the seminary. The 1 year of suspension, I spent it in a school called Imperial College in Arua, a private school. By the time I was to go back to the seminary, I was already in senior 6. So I finished my senior 6 and became one of the best students in the whole of Arua district. And then came back to South Sudan. I was admitted in 2005 in Makerere University to study either urban planning or law, but I couldn't afford to pay. I came back. So I was in Yei when CPO was signed. We were in Yei, we came to Juba, and I stayed for almost 2 years out of school because I could not afford. Then in 2008, I went back to the university in Uganda Christian University. Then I did my degree in law.
What were you doing in those 2 years?
Well, I was of course a child soldier. I was in the army. Then we were demobilized to go back to school, and then thereafter I got some work with an NGO called Mercy-Corps. But I was basically doing work with young men and women on how to avoid conflict and violence. So I was put in charge of Baragazal region, the 4 states in Baragazal. So I was moving in between Rumbek, Tonj, Wau, Awil, etc. and ABA. Then thereafter, of course, I went back to the university, did my university, went to LDC, became also one of the best in LDC, then went to the US.
What's
at Harvard
LDC?
Law School.
It's like
Law Development Center. It's a postgraduate school for anyone who wants to practice law.
And
in Uganda.
So you went there and you did well.
Yeah.
And how did you get to go to Harvard?
Well, when I finished from Law Development Center, I came back to South Sudan. I was in Juba, tried to start practice. I started with Muller and Co-Advocates, which a law firm that was being run by Dr. Richard K. Muller. By then he was busy in the parliament. That was 2011, 2012. So I was managing the firm. After that, I left the firm, went to be the legal manager for KCB Bank. Then after that, I applied to go to Harvard. That's when I went.
Was it easy for the application process?
Well, I cannot tell now, but I would want to think that at the time was a bit difficult. But sometimes it's not easy to have memory of what happened really exactly. But I think I did what I could do because everything is processed online, and so I was able to do that. What was the duration of your time at Harvard?
It's
1 year. Yeah.
Okay. So you did a 1 year there?
Yes, I did a 1 year. I was to do my PhD. And then my mother was unwell, so I had to put it on hold and came to just take care of my mom because I'm the firstborn in the family. And also, since I lost my father, I was the only person left. I'm the only child of my father from my mom. So I had to, come back and take care of my mom.
So you started practice here in which year after you're coming back?
2011.
2011.
Yeah.
So from 2011, you have been practicing law?
I've been practicing. I practiced a bit, then went to the corporate world. I was at KCB. Then went back to school and then came back. I've been practicing since then.
So what kind of law do you practice?
Mostly into corporate law and finance.
Yeah. What does that involve?
Well, basically it involves transactional law, that is business, anything to do with business and finance.
So acquisition, ownership,
conveyancing, whatever it is. Yeah.
When was the first time you kind of did a deal that you realized, like, okay, now I'm in business?
Well, it's difficult to tell because one thing about practice is that it's a cumulative process, and I think what I would say is that I wasn't into deals. Like corporate business. It's not like people do deals in conveyancing or some specific contracts, maybe government related, etc. But with corporate law, I was more or less really not do like deals that I would say, well, I'm into business now. But I think the time when I realized I was into business was mostly when I was able to reach out to a number of international NGOs and international organizations were able to reach out to me to be able to support them. That's when I realized I was in business because at the time, I think there were very few law firms. Of course, very good law firms with very good lawyers. And I think I was also a valuable addition to the industry. And when they started coming to me, and I realized that, okay, that was when business was coming in.
You say that there are very few law firms with good lawyers, good law firm. Are you saying that to contrast that right now? How is the law practice right now?
Well, I would say that the law practice is now a little bit saturated. There's a lot to do with quality, which is of a worry. And of course, so many lawyers in the market. And the market is more or less Juba-based, with very little outside Juba, because this remains the commercial center of South Sudan, and but there's really little going on in some of the cities. But I think with time, as the economy grows and improves, I think that's when we'll be able to see a difference.
What are some of these quality issues when you look at
Well, I think one of the quality problem is that we do not have continuous legal education to work on the quality of lawyers, because as a lawyer, you must be able to, grow yourself every day. And so if you are unable to do that, that becomes a problem. And
so you need to study what case law, stuff like that? Or
not only case law, but I think there must be a way that you're able to, do something that adds into the quality of your mind or your brain in terms of law. And again, the other challenge is that our legislation that governs legal practice is a little bit shallow, the Advocates Act, and we still do not have regulations or remuneration, and so it affects the value that comes with practice.
So the regulation, the Advocates Act, it's like kind of like sets up a body almost like the engineering board or whatever. Mm-hmm. It sets up the bar association, right?
It sets a number of things, because there are a number of institutions that because what is key really to legal practice is a bar council. And the bar council is a body that licenses advocates, regulates advocates, and does everything about advocates. And is an institution that is composed of people from the judiciary, people from the Ministry of Justice, and people from the private practice. And the bar association is more or less just an association that brings the practicing advocates together and advocate for their welfare, etc.
So it's like the journalists' union. It's
yes. Yeah.
So it's a membership. Should it be a membership-based organization?
It is under the law, a membership-based organization, and then the bar council is more or less like say the media authority.
Like a regulator.
A regulator, yes.
What, do we have the bar council?
Yes, we have the bar council.
And then why is the bar association so much? I don't want to use the word overblown. Why is it overemphasized? Because the current one seems to be licensed advocates. It licenses.
No, it doesn't license advocates. The bar association doesn't license advocates.
Does it withdraw immunity?
It is the bar council that does that. It doesn't as well.
Okay, so, but I see people saying that the bar association.
Well, it is because it's more or less of a social organization, and that's why people are fighting for it. But the regulatory body is really the bar council, and since it's a professional entity, that's why you don't see it in the limelight.
But what does it do now, the bar council? Does it license?
Yes, that's what does the licensing, that's what does the disciplining, that is what does the withdrawal of anything to do with advocate, that's what does everything to do with even if it is to set guidelines for continuous legal education, etc. It is the bar council.
Who is the head of the bar council right now?
The bar council, automatically by the virtue of law, is supposed to be the president of the bar association. So now,
okay. Now this is getting interesting now.
Yes, and so because it is organized in the way that it is a membership-based entity, the bar council. Yeah. So you do have 2 members from the judiciary.
But the members, organizational seconded members, right?
Yes.
Not individuals.
Yes. So the judiciary bring people from the judiciary who are judges or justices.
Yeah.
2, and the Ministry of Justice bring 2 directors from the Ministry of Justice. Yeah. And then, of course, the Central Committee of the Bar Association brings about 4 senior advocates.
Okay.
And, of course, plus the president of the Bar Association to make 5, so that constitute the Bar Council.
Is there any age, gender currently quota in this representation, or it is?
No.
Is there a likelihood that it's all men right now as we're talking?
There is a possibility, but of course that hasn't been the case.
Okay, it hasn't been the case, huh?
Yes.
Okay. Now, this is very interesting. I've never had it. What about the law institution? That does the law sets another institution for the law development?
Yes. We do have what we call the Legal Training Institute Act. That is set to, establish what we call the Legal Training Institute. And now the Legal Training Institute has a mandate of conferring diplomas in legal practice to graduates of law.
And are there any paralegal provisions also?
Yes. So there are courses that they would put in place, like maybe diplomas in law, etc., that are not diplomas, not like postgraduate diploma in legal practice, depending on how they would want to set that up based on the curriculum that they might develop for the purpose. Now, this is how it works. Now, you go to law school, you spend 4 years, you graduate, you have a degree in law. You are a holder of degree in law.
You're not a lawyer.
You're not a lawyer.
And you're not an advocate.
You're not an advocate. And now, what is required of you is that you're supposed to enroll for postgraduate diploma in legal practice.
Okay.
Now, that's where the Legal Training Institute comes in. That is where the Kenya Law School,
Kenya Law Society, School of Law
comes in. Yeah. That's where what we call the Law Development Center of Uganda comes in, the LDC. And so ours, we have the Legal Training Institute. So you can.
Do we have it, or we have
we have the law in place.
We have the law, yeah.
Yeah. Now the challenge has been the establishment, because we need to have the institution in place, the structures, and then of course the human resource to operationalize the institution.
Does the law instate how it is supposed to be established, how it's supposed to be financed, who's supposed to be running it?
Yes.
Does it get money from the finance?
Yes, from the national government.
From the national government?
Yes.
Why has it not been set so far?
Well, I think it has been an issue of resources to establish it. That has been the challenge.
But the cost of not having it is higher.
It is higher. So that goes down to policy decisions at the government level.
Do you think, is it lack of information or political will, or?
Well, I think also has a number of variables at play, really. And I think when we have an established, I think when these elections that you already know happen, I think the desire is that the institution should come together and see that this is established, because the Ministry of Justice has a mandate in it, the judiciary has a mandate in it, and the lawyers who are practicing have a mandate in it.
But that's a very bleak image of so these lawyers basically, a lot of these lawyers just have their degrees, unless you go to a law training institution outside the country. All the lawyers who are currently in this country, they have not undergone a legal training center.
Correct. And the ones that we have here are that, because since we don't have the institution in place, we also we provided for an alternative solution, and the alternative solution is that if you finish your law degree, you're not licensed to be an advocate. You are to be attached with a law firm.
Yeah, there's a 1 year training. Is it kind of like a residency or pupillage?
Yes.
But I understand. Someone told me this is all around. Get me tea and go and print this document.
Well, you could say that, but again, it depends on the law firms, because the people that we have trained who have become very good lawyers.
Do you think this pupillage is being abused in some places?
It is in some places.
In which manner?
Well, in a manner that probably someone has not qualified and they are recommended to be licensed. And I think there is no proper guideline on how that pupillage can be evaluated.
Yeah.
And to see how it can be verified.
Even quality, how many people can be at a certain law firm? Does it have the quality to?
Yes, that's another issue. Even how to distribute potential trainees to.
Because if I have a small office in Konyokonya, I say I trained 10 people this year.
That's where the challenge is.
But this is. Do you think there is a culture clash between lawyers who are trained mostly in Sudan and lawyers who are trained in East Africa, and even some who are trained in the West?
Yeah, that is obvious. I think culture is culture. Culture depends on the community you come from, and culture changes every day, depending on how people appreciate evolution in society, and the same with law. So in terms of behavior, in terms of conduct, how people conduct themselves, how people carry themselves, how people address themselves, these differences are out there. So you will find lawyers probably trained in East Africa have a different way of looking at things and of addressing things, and lawyers probably trained in Sudan have a different way of looking at things and how to view things. But what is important is that the baseline is the same. The law is a law, and I think that's where the point of convergence is.
Yeah. But a lot of the institutions that are working right now, they're basically really Bashir era Sudan institutions, like the judiciary, the prison service, and even the police. I mean, the law has changed, but like a lot of the cultural, what do you call it, the institutional heritage and the institutional cultures is pretty much still a Sudan era institutions.
Yes, I agree with you on that, and I think this zeroes down to what the government way of life is or culture, because government is an institution, has a culture. And I think when we became independent, we should have, done better by seeing that we having a cultural revolution at the time in terms of transitioning our institutional structures to our culture into what we wanted it to be. And I think that's why also we're having struggles with our institutions. What the law says is different from the practice that is being done there. And these are very common.
This difference is how wide does it get at times?
Well, it's I can give an example. Let's say land, for example. Say land, for example. Now, our law talks of us owning land in terms of either freehold or what they sometimes refer to as fee simple. You hold a title in perpetuity. Or
that means it's like it's
forever. You die, your children inherit, etc. And also the law talks of you can own a land in terms of a lease. So assuming you don't have a freehold title, you can lease. And this is a provision to cover for foreign nationals, etc., or even nationals who would want to lease land.
How long can you, what is the maximum length?
Well, the maximum could be 99 years, etc. And then, of course, you can have, public lands, and then you can have community lands, etc., based on our law as it is. Now, if you look at the practice, our practice still embraces the law of the Sudan then, where land belongs to the government or the state, and the state regulating its ownership, etc. Yet our law now talks of land belonging to the community. And unfortunately, if you see the whole of South Sudan right now, I think none of us own a freehold title. We continue to get leases from government of a land that the government does not own.
So when you get a token, is that what is it? Is that the token or that is the
I mean, we talk of the lease papers.
The lease papers from the ministry.
So the lease papers tells you that the government has leased you land, yet the government does not own any land apart from the public lands that the government own. So which are very specific.
What the government should do should hold the record of saying this guy owns that land.
Yes.
Instead of saying I give you this
a lease. Yeah. So now, if you ask yourself, how does government lease land that doesn't own? This now, if I have,
so you think that is a inherited cultural practice?
Well, this is a cultural practice from the Sudan. So we should have transitioned now into having a freehold title, so that all citizens have freehold titles. Then foreigners can only have lease for the periods that are there, and this is where the challenge is right now. So,
when you go, there are a lot of issues of land disputes here in court. Whenever people go and do this, but people don't discuss this. Is this something that is being disputed in the courts, or it is mostly like, hey, this land belongs to who?
Yes, it's more or less of, hey, this land belongs
mostly,
to but not really the issue of the system or the tenure or ownership of land.
Or the constitutional or the legal provision.
Yes, that is not really the issue yet now. So I think government is trying to do what it can do to, move through that process of transitioning land into the different concepts that we have put in our law. Because there's history to that, and there's a reason why we have the law as it is.
What about in terms of criminal justice reforms? How much of the baggage of the Sudan is impeding kind of progress in criminal justice reforms?
Well, I wouldn't say how much of it because I don't have any statistics on it, but I think more or less same system, same structures, and I think not until we're able to really build a system that is reflective of how we will want to have our system in
A
place.
lot of people say a woman cannot do dhamana, cannot do bail. Is that true?
Well, these are some of the issues that we're having.
Does the law state that?
Well, the law doesn't say, but an issue of practice, and this is where the problem is.
So, like right now, if a woman goes, she can actually face a challenge of not being able to bail someone.
True.
Though it's not anywhere in the law.
We have those problems. Even now, for you even to move with the child out of the airport, they will tell you who is the father, etc. So we have those things. So
a man can move out of the airport with a child, but a woman needs.
Yeah. So these are some of the things that I say in terms of the cultural difference, and also the clashes that we have in terms of lawyers coming from different jurisdictions and the practices, etc. So not until we're able to have a harmony, then we're able to get parity in terms of how we practice our law and build our legal culture.
So who is the custodian of kind of that cultural transformation? Is it the Chief Justice, the Minister of Justice?
No. It's a matter of law. It's not like an individual.
Yeah, but the law is there. But the person who champions the law.
Well, all of us are stakeholders, including yourself. But what I would say is that there are institutions that are supposed to shape that culture, and one would have been the Legal Training Institute, because lawyers that would have come from all jurisdictions. Yeah. If you're from Kenya, Sudan, Uganda,
kind
Canada,
of creating
US.
something of our own.
Yeah. So if they would have come into the country, then it would say before you practice in this country, you have to go through a Legal Training Institute that tells you how our systems operate here. So we don't have the divergence in culture and how people conduct themselves. Because this Legal Training Institute would have trained us on how the legal practitioner would practice, how the judges would be on the bench, and how the prosecutors would be also on the bar. And so that is where the issue is. Yeah. So I think it's very critical that we have the Legal Training Institute, because the Legal Training Institute has a say in how we shape the culture, the legal culture in the country.
Talk to me about prosecutors. They hold so much power.
Well, I cannot talk on that because I'm not one of them, and I don't know about.
You face them?
Well, I face them at the level of being an advocate, but in terms of institution, I think I don't have the expertise to talk on it.
Could prosecutors' discretionary judgment make someone's life hell?
No.
Yeah. They're supposed to apply the law?
Well, that is what it is, because now competencies of offices are defined in the law, even of courts, be it from the county court to the Supreme Court, all the competencies are defined in the law. So we don't act in whim, we act based on what the law provides in terms of what you can do as a judge of a specific grade versus any other case scenario that you might face.
What about the traditional courts?
It's the same. There are also domains under the Local Government Act that defines what the traditional courts can do.
What kind of cases can they rule on?
Well, mostly family, marital, cultural, but they're all well defined in the local government.
They're all well defined in the
local government.
Is there places where there is overlap at times?
Sometimes we do have those.
Or overstretch of authority?
Yes, we sometimes have those cases, especially where there are no institutional structures in place that ensure oversight and compliance. Because now we do have a challenge in the country where some places even the formal courts do not exist.
So these traditional courts rule
they try to cover in the gap, and this is why we find a lot of challenges.
So are there places in this country where the traditional court acts almost as like?
There are places.
So in cases of homicide, or what do you call them?
Yes, murder, etc. Yes, we have had those.
Isn't that a bit risky to leave
someone's
life on the hands of probably basically chiefs?
It is, and mostly also those chiefs try to use traditional knowledge and traditional law in terms of how to resolve such issues, because these formal structures came in the recent past. But before they came in, we used to have our traditional way of handling things. So again, although it's not within their competencies, I think also they have traditional guidelines on how to resolve some of these issues in the absence of the formal systems.
And you think that's at times people are satisfied with that to some extent?
Well, there are pros and cons of that because I can give you an example of sometimes someone is murdered and the families have an understanding that in our tradition, when someone kills somebody, there's a blood compensation of say this.
Cows or this number.
Yeah, and somehow there is a positive to that the principle of an eye for an eye makes the whole community blind because one has been lost. We don't need to kill the other, but blood can be compensated so that the family of the deceased can be able to get out something out of the lost life and also save one life. But again, there is also a negative to it that those who are rich enough can go away with murder because if I'm able to pay for a life, I can do anything that I want. Of course, but there are, of course, parameters where if it is really deliberate, you can't do that. But again, you cannot rule out the power of human beings to be able to maneuver their way through situations. So there are positives and negatives to that, and there are also a push to see that we don't see as a way of creating a loophole or a lacuna where some people can exploit it.
Come close to the mic.
Yeah.
Do you, in terms of the capital punishment is in our law, right?
Correct.
And there is a provision for it under a certain threshold.
Sure.
And someone has a right to appeal.
Correct.
Do you think the death penalty is something that we should have it?
Well, you see, every society has its own growth, and there are variables that influence how people look at whether something should be done with or something shouldn't be done with. In the circumstances attaining right now, I think the death penalty should be in our books until that time when we're able to, grow as a community to be able to say, well, we don't need the death penalty anymore.
Why do you think it should be in our books?
Well, I think
from your answer, I think you think it's a societal referendum.
Yes.
To have it.
Yes.
And you think right now, from your view, the society kind of has
yes,
conferred.
because we're a community that is still very violent, and we so much still do not value human life the way it should be valued, and so it should be able to act as a deterrent, a punishment to those who might think it's easy to take away life and go away with it. And again, we have a society where when a murder is committed against my family, we could take the law into our hands, and so to avoid all these
all revenge
and all, yes, and that's why we need it there, because now if we say no more death penalty, we're opening the floodgates for revenge, because
so
revenge is so easy. There will be more deaths, yes, and this is where the problem is.
What is the statistic on the death?
I don't have the statistics. I don't have the statistics.
But we're in the region. We're there.
We're there. We're there. Yes, we're there. We're there. Yes.
So that's a very interesting view. So you think are there a lot of legal issues that the society needs to have a referendum on it instead? Like the society needs to have almost like a say on whether it should be there or not.
Well, but the law doesn't work in vacuum. The law is a reflection of our views and aspirations, and whatever the law is, it is what we want it to be, and so the law doesn't operate in a vacuum, and therefore, without our views, without capturing what we are and what we want to be, I do not think that the law would be any different.
Do you think there should be discrepancies between regional and state level application of the law? Because right now there is. I mean, in other places, almost some. I mean, you see in Lake State, for example, what the governor is doing. There, people are saying, you know what, look, this is working for us. Do you think like states should have the right to implement their own ways of
No, it doesn't work like that. Even Lake State, they're applying the common law that applies in Central Equatorial, Eastern Equatorial, Western Equatorial, and Upper Nile is the same law. The difference is that probably the security agents in Lake State are more effective, and they are in control, and there is a political will.
Someone would say they are brutal.
Well, I don't think, I wouldn't say they are brutal, and I wouldn't say otherwise because I have no evidence to point to that. But my view is that they are more effective in implementing what the law is, and I think there's more desire from the state to see that there is rule of law, and that is what makes the difference.
That's what makes the difference.
Yes.
Let me talk about your career a bit. You've been involved in few high-profile cases.
Correct.
Most notably, the case of the G10 or what they call the former detainees on the end side of the conflict in 2013. Talk to me about the process of you getting involved in that case and what was at stake.
Well, when of course this thing happened, we were all here, and when time came for them to be arraigned in court, families of the detained were able to reach out to us. We had been here, we had been with these people. Some of them were our clients before they got into what happened. And some of them we knew ourselves all the way before even CPA was signed, when we were in the liberated areas, and when we became lawyers because we are their boys. They know how we came up into what we are today, and we supported them as their lawyers when they were still in government. And so when the unfortunate event happened, I think their families were able to reach out to us to be able to represent them. And that's how we got involved.
Well, was it your first time making a case, such a high-profile case, where the state is the other party?
Not really, but of course in terms of magnitude, yes, because based on our law, every criminal issue is a state issue.
It's a state issue, but
So
this is really a state issue.
Yeah, now this is really a state
because
issue.
the charge was what, treason?
Yes, they will have charges of treason and
it's a capital.
Yes, of course, it's a capital offense. Yeah, treason, murder, etc. A number of counts that they were charged with, and so yes, that I would say yes. That was one of the major issue that we handled at the time.
Is that the case that made you think like, okay, I need to go to commercial law?
Not really, not really. By training, I'm a commercial lawyer, so but a little bit of criminal law here and there, but it's not my kind of business. It's not my kind of pie that I like biting. But of course, in my law firm, I do have people who are specialists in terms of criminal practice. So it's just a matter of where you think your niche is and whether you can build on it.
Do you think, did you get any bit of some hostile treatment after that case, or a little bit of push here?
Well, yes, those pushes were there, but again, it zeroes down to perception. And people don't appreciate the importance of legal representation, because it's today you, tomorrow might be me or somebody else. And how we stand by one person must be in the same way we will stand by another. And what happened with the case of the former detainees is that either way, even if we never represented them, the state had a responsibility to provide them with legal representation. With legal representation, because that was a capital offense under our law, under our constitution. If someone is charged of capital offense and is unable to get a lawyer, the state has a responsibility to hire a lawyer to represent that person. So either way, still, the state would have gotten them lawyers either way. And so if there were challenges, because now this was a politically charged situation, there are people who felt like these are people who wanted to overthrow government. Why should they be represented? They deserve to die. And there are people who say, no, that cannot be the case. Whatever the circumstance, everybody must undergo, fair trial, etc. And of course, people had those conversations at the time. But what I would say is that the government also did its part to ensure that the process was smooth. The lawyers did their job, because the government would also want to see that the court was looked at as a kangaroo court, where these people are being tried and an outcome is reached and they are not being represented. Because there were a lot of conversation that, okay, there was coup, others were like, there was no coup, this was a setup, etc. So I think it was fair enough that...
for it to go through the courts.
Yes, went through the court. But at the end, even before a decision was reached, a settlement was able to be reached, and these people were released, and they were able to be moved to Kenya.
There was also political mediation.
Of course, political mediation was going on the ground between the Kenyan government, I think the East African, the IGAD community, and the government of South Sudan. Yeah. That is how things moved.
Let me talk to you a bit about the peace. We have a peace agreement. Like currently, the peace agreement, the RCES or whatever, the revitalized peace agreement, it's almost like a constitution or an adjacent to constitution to some extent, right?
Yes.
So the peace agreement is part of the law right now. How does it deal with the transitional constitution?
Well, the point here is that when this peace agreement was signed, there were provisions that were, of course, the desired thing of the peace parties or the agreements, the parties to the agreement was, to resolve the root causes of the conflict that happened in 2013 and subsequently 2016. And there were a lot of ambitious plans in the peace agreement. And it went as far as that the peace agreement would be inculcated into the transitional constitution, and that where there was even a contradiction between the constitution and the peace agreement would prevail. And so there were really ambitious provisions in the peace agreement. And I think when the peace agreement was signed and it was incorporated into the constitution, it became part of the constitution. And so that is where we got ourselves into all these difficulties in terms of,
Do you think that creates more questions than answers?
Well, the point here is not about questions and answers. The issue here is we were trying to mix a number of things together, politics and the law. Of course, the underlying principle is that power is to be kept. Power is to be kept. Even if today Nelson Kwaja becomes the president, you'll want to keep power. And so the ruling party, SPLM, desire is to keep power. And so anything that waters down its power, of course, that would be probably resisted in every way possible. And therefore, I think that is where the challenge came with the implementation of the peace agreement. Because the peace agreement, in a way, wanted to water down, of course, take away the powers of the president. So if you even look at these divisions of, this issue of having five vice presidents and distributing them into clusters was basically was in an attempt to disarm the president of the too much powers he had then. So that now governance is somebody handling maybe RIAC, economics is Waniga and the team, infrastructure is Tabandengai,
then I have youth,
gender, blah, 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 is Rebecca Nyandeng. So I think that was the engineering behind it. Remove some of the powers of the president, vest in these vice presidents, so that, there is a way of, trying to bring about a balance.
That is a more expensive government.
It is. It is very unnecessary. Look at the population we have. We don't deserve this kind of a government. Because if you look at this kind of government right now, what services does it deliver to the people? It is taking away all the revenue that is meant for development of this country.
A slim government,
I don't think even this country deserves to have more than 20 or 25 ministers, no.
What about the MPs?
Very unnecessary. I don't think even we need 200 MPs. If you ask me, I would rather have even 70 or less than 100 MPs. We'd rather have less than 100 MPs.
Because then they will have a... Yes. But do you think the current constitutional amendment process, constitution writing process, will yield something?
Well, that's my hope, because we can't continue having transitional constitutions. We should be able to have a permanent constitution, and we start having a new life based on the new constitutional regime.
Isn't it conflicting to have a parliament that the parliament itself is supposed to vote on this constitution, do you think that parliament will be, this is kind of, there is a reverse incentive, say, well, will the parliament be willing to do a constitution that will reduce their numbers or their...
Well, nobody knows. The MPs know better.
But the MPs will they're the ones who to vote on the... I mean, the constitution is a wider thing because it's also almost a...
Well, there's still a conversation on the framework and the law that I've been working on. So let's see what comes out of it, because that's why you see there is a challenge. Others are saying there shouldn't be an election until we have a permanent constitution. There are those who are saying let's have an election so that then the people who have voted will be the one to take part.
Or people are saying let's have a kind of an undertaking, almost an undertaking agreement that says, hey, the new government will then do the...
Yeah, but who will agree with who?
Or some people are saying let's have a partial election, let's have federal, and then let's leave the other things to come later.
Well, either way, I mean, but the issue is the parties prepared for the election.
Do you think if there is an undertaking, whoever signs it when they reach the other side of the
issue
river...
is also, do they have the funds? Because it's an expensive venture.
It's an expensive endeavor.
So there are a number of variables that are to be looked at. It's not only saying let there be an election. Do we have the resources to conduct it? Of course, it's not difficult to register people.
But isn't it expensive not to have an election?
It is also expensive, but
it can mean...
But you need to do your risk analysis to see what is greater. Where is the greater good? Where does the greater good lie? Is it in having an election or not having an election? And people should have an honest conversation on these issues, especially the political actors. Is
that conversation being had right now?
Well, it is, I think. I think they haven't yet sat around the table. But if you follow what is going on in the media, there is a talk of maybe the partners through RGMEC will sit to have a conversation on whether they should have an election or not.
In terms of the discussions, do you think the discussions are a bit are people a bit free in having those discussions in talking right now? When you see people speaking on social media on what, has it gotten better or worse in terms of freedom of expression? Or
well, it's difficult. I don't have statistics to see whether we have progressed in terms of freedom or not. But of course, people are talking. People are talking. I see it on social media, or radio talk shows, civil society organizations, political parties. People are having a conversation. As to whether there are people who feel they are not free to provide their view on these issues, I can't tell exactly right now, but the conversation is ongoing.
Are there red lines?
I don't think there are red lines so far. I don't think there are red lines.
Yeah. I want to conclude by talking about the bar situation. Like right now, you sit in the commission, in the election?
Mm-hmm. Election commission or election committee, yeah.
Election committee for the bar situation. Yeah. So now, is this the last election that the bar association had, it ended in a bit of chaos?
Correct.
How many years ago? That's 8 years?
2014, 15.
Yeah, so around there. Mm-hmm. And so how was the bar? So for the past, after that chaos, there was parallel bars?
There were a number of parallel bars, yes.
There was parallel bar associations?
Yes. Competing
and claiming to do the same thing?
Correct.
And then right now, what is the task of this committee? To say like, we want to end that chaos?
Yes. Now the task of this committee is to conduct that elections. And we're in the process. It's happening next Wednesday, not very far from now. And I think we are almost there.
What makes you think that chaos, that the same chaos will not come again?
No, it will not come because this is a committee that was set by the Supreme Court. And our mandate is very clear. And right now, what is important is the fact that all the parties have committed into this process. As you might have known, I think you have hosted the two groups, and I think they are really doing a good job right now. The two groups, what is underlying for us lawyers is that whatever the differences or whatever the divergence in views, we still remain the same legal profession, and whoever wins will have to work with everybody because our interests are all the same. What matters now is to get a leader that represents everybody. Whoever wins from either camp will be a leader for all, and will work for the interests of all the lawyers.
Some of them we hosted both of the groups here, and I mean the other ones, they call themselves they're the peasants, they what do you call it? The marginalized, the representative of the people, and they see that the other group is a bit flamboyant and almost like a favorite, a darling of the state, and they're the ones who are coming to do reforms. And you have the Advocates Alliance, and so you have the RP, the Reform and Prosperity. When you look at this stuff, do you think this is election stock? Both of them are probably.
No. These are all our advocates. Whatever camp they belong to, they are all advocates. Whether one is this or that really is a matter of perception and how they brand themselves. Because branding is branding. Every group has a way of branding themselves based on the values that they stand for. And so for us, we wish the best candidate to win, the one that the lawyers would want to see them lead for the period that they will have. And then life goes on.
Don't you feel a bit awkward that there's no woman?
I don't feel awkward because nobody tells anybody to run for any position. The women should be able to claim their space. We are all equals as advocates. Nobody would have said, why are you running? If there was a female candidate, I believe she would have also competed well with the other two groups. And so I think it's a challenge for the women lawyers. What is unfortunate is that if you look at, during all this process, the women lawyers are more organized anywhere. Some of us even surprised that there was no woman candidate. And even in terms of the two camps.
There's no woman candidate in the three main positions.
Yes, so I'm even surprised that they are the most organized people. And also these talks, this really reflects a lot on the fact that there is more to talking. There's more to doing than talking. So the women really need to,
But should you blame the women or the men? The men are the ones who are taking this position.
No, I mean, listen, the world is run on interest. The world is run on interest. Where is their interest? You can only fight for your interest and secure your interest. That's how it is. Even in the bar. The women should have said, well, we are organized, we are a constituency of our own, we need to sit on the table. Nobody's going to give you. If the women sat as a group and said, we want to be on the table, you either give us what is ours or we don't vote for you, they would have gotten their share. They would have either been the president or the vice president or the secretary general. Nobody would stop that. And I can tell you they are even probably equal to us in numbers.
In the bar?
Yes, in the association.
The membership. Yeah.
In the membership. So, I mean, it's an issue of probably not knowing what their power is. They probably don't know their power, or they never had in place strategy how to get what is theirs and secure their own interests. But you never know. I mean, there are a number of things. So probably there are strategic positions that they're targeting. Yeah.
Okay. Ajo Noel?
Thank you.
Thank you for coming to the RecentPast.
No problem. Thank you for having me.